Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. We're going to look at a recent case involving the FCRA, the Fair Credit Reporting Act, and in particular, sort of a growing issue among courts, at least certain courts, who distinguish between what they consider to be a legal dispute between you and the credit bureaus, and then a factual dispute between you and the credit bureaus. And basically, the legal dispute, if that's all it is, then you tend to lose that. If it's a factual dispute, then your case moves forward. Now, I don't agree with everything in this decision, and I certainly don't agree with what all the judges around the nation are saying about this. What's a factual, what's a legal dispute? And there are plenty of judges that don't buy this distinction. But let's just take a look at this because this is from the 11th Circuit, which is where I practice. It's the Northern District of Georgia. The 11th Circuit is Florida, Georgia, Alabama. And this is, I think, a well-written decision. I may not agree with everything in it, but we certainly want to see what this judge has to say. So basically what's happened is the case originally went to a magistrate judge who is not a lifetime judge. Okay? And the magistrate judge can make rulings, but these are really reports and recommendation. And then if somebody objects to that, the district court judge, which is the lifetime judge, will take a look at it and decide what to do. And here we see that the court adopts the report and recommendation and denies TransUnion's motion to dismiss. So here are the facts. And really the important part of the facts are all going to be in this first paragraph. And this is taken from the lawsuit that the plaintiff filed. Plaintiff says, look, I bought this Nissan, I paid for it, my daughter had some problems with it, took it to Sam's Club garage, and at some point they contact Regions Bank, who then has the vehicle towed. Now, she says, hey, nobody ever told us about this, and then we get this collection letter, and she says it was improper for the Nissan to be towed, and she never asked for it to be towed, and she paid some money to Regions to basically get the car back. So that's all happening at the end of 2018 and in January 2019. Well, guess what? February 2019, Regions starts saying that there was a voluntary repossession. So repossession is where somebody takes your car. Voluntary repossession is where you would take the car to the dealership or turn it over to the finance company. And so this is reporting on her credit report. And so she does some disputes through the credit bureaus. Those credit bureaus, credit reporting agencies forward the disputes to Regions Bank. And then she says in March she was denied a lease. Well, why? If you have what's called an adverse action, the company gives you that adverse action. In other words, you don't get the loan, you don't get the lease, you don't get whatever it is you're applying for. They need to tell you why. And they say, hey, it's a recent auto charge off and voluntary repossession. Well, that's what she was dealing with the Regions. And so after that, she says, hey, I'm sending more dispute letters to the bureaus. And ultimately, this does not get fixed. Okay. And so she sues and says, I've been denied credit and I have a tremendous amount of mental and emotional distress. So what's her claim? Well, it's really just one claim, and that is under 1681I. An easy way to remember this is the I stands for investigation. So you sue a credit bureau, you say, I told you about a problem and you did a lousy investigation. That's 1681I. And she says, look, TransUnion failed to delete inaccurate information. They were on notice of those inaccuracies and they knew what the problem was. And she says they failed to conduct lawful reinvestigations, failed to maintain reasonable procedures to verify dispute information. And basically, she says, Regions Bank or TransUnion just said, hey, Regions Bank, whatever you say, hey, we're going with that. And that's true even though TransUnion knew Regions Bank was an unreliable source of information. And then she alleges that TransUnion has a regular policy of ignoring dispute information from the consumer. In other words, they just will take whatever the word of the furnisher is. And she says it's objectively unreasonable to rely on verification without conducting an independent investigation. And in other words, you have the consumer says one thing, the furnisher, Regions Bank here, furnishes the information. They say something else. Well, the credit bureau needs to go in there and actually investigate. And so again, she claims she has damages. And she also says this was reckless, and so she can get punitive damages and statutory damages. So here, as the judge is writing this, in July 2020, here's the posture of the case. So September, their TransUnion filed a motion to dismiss, and then the magistrate judge recommended that that be denied. Now, the magistrate judge said, I am a little bit concerned about, is this a legal dispute or is this a factual dispute? And TransUnion objects to the report and recommendation for two grounds. So first, they say the judge erred in declining to find definitively that plaintiff plainly alleged a legal question, which TransUnion has no responsibility or capability to resolve. And then second, they say the analysis, let me just get this highlighted, the analysis of whether plaintiff's dispute is factual or legal is not only proper, but necessary. Okay, so the magistrate judge said, I think it's a little early to do this. Well, TransUnion is saying, not only is it not too early, it's the absolute time you must do this. So we'll kind of skip over this evaluation of report. That's just some law on that. A motion to dismiss. I do want to cover this briefly. So for your lawsuit, it needs to be a short and plain statement of the claim showing that you're entitled to relief, and you have to give the defendant fair notice of what the claim is and the grounds upon which it rests. And then the court says, we'll accept all facts in the complaint as true, and we'll view these in light most favorable to the plaintiff. So if it kind of can go either way, there's certain facts that you go, well, I could see it from this way or that. Well, you got to give the benefit to the plaintiff. But they say legal conclusions are not entitled to that assumption or presumption of truth. And conclusory allegations will not stand in the way of a motion to dismiss. So here's the analysis. So now we got all the background, we got the facts, we understand the law, we understand kind of what's going on in this case. Now let's see what the truth is according to this judge. So the judge starts off and says, well, what was the FCRA, Fair Credit Reporting Act, enacted for? And it's to require the consumer reporting agencies adopt reasonable procedures for meeting the needs of commerce for consumer credit. It's got to be fair and equitable. And there has to be accuracy and relevancy. And so stated another way, Fair Credit Reporting Act is intended to prevent consumers from being unjustly damaged because of inaccurate or arbitrary information in a credit report. So now let's get into the section 1681I. Remember, that's the investigation section. And it says, get this highlighted, this sentence here. If a consumer disputes the accuracy of information contained in a consumer file at the credit reporting agency, and by the way, there's all different terminology. Credit bureaus, consumer reporting agency, credit reporting, it's all the same thing. The agency shall conduct a reasonable investigation to determine whether the disputed information is inaccurate and record the current status or delete the item from the file within 30 days. So what do they do after an investigation? Well, the law is pretty simple. If it's found to be inaccurate, or number 2, incomplete, or number 3, cannot be verified, then the credit bureau shall promptly delete the item of information or modify that item as appropriate based on the results of the reinvestigation, and then notify the furnisher that the information has been modified or deleted. So now the court's going to say, here are the 5 things that you have to allege that these are called elements or requirements for a cause of action. So if you want to sue the credit bureau under section 1681I or 1681, I, you have to have these 5 things. Number 1, there has to be inaccurate or incomplete information. And we talked about this in a recent video, that there really does have to be inaccurate information. If the information's accurate, you really don't have a claim. Now, number 2, you notified the bureau of that inaccuracy. Number 3, the dispute is not frivolous or irrelevant. Now, frankly, that's not something you as a plaintiff have to prove. That's something the other side has to prove. So the judge is putting it in here now. I don't think it's exactly right to say this is what the plaintiff has to prove. But number 4, the credit bureau failed to respond or to conduct a reasonable reinvestigation of the disputed items. And then number 5, that failure to reinvestigate caused you out of pocket, so we'd call that economic damages, or non-economic or intangible damages such as humiliation or mental distress. And this is buried in the middle of this paragraph, but it's very important. Accurate reporting is a complete defense to a section 1681I claim. So if it's accurate and the credit bureau does not do a proper investigation, then unless there's something really unusual, you will lose that case. So the court says, well, look, I agree with TransUnion that the 11th Circuit, so remember that's Georgia, Florida, Alabama, case law teaches a factual inaccuracy is required to state a Fair Credit Reporting Act claim. And that's what you have to do. I mean, if you don't have that, then you have no case. And then this is where the judge is going to start reviewing a bunch of case law. So it says, reasonable reinvestigation does not require the credit bureaus to resolve legal disputes about the validity of the underlying debts. So this case, Humphreys, involved a collateral attack on the validity of a debt. And then they say, we're not talking about resolving legal disputes about the validity of the debt. Reinvestigation claims are not the proper vehicle for collaterally attacking the legal validity of the debt. And then if we're talking about legal issues, that's going to be something that that credit bureau may not be qualified or obligated to resolve. And so the judge here says, well, look, the magistrate judge was hesitant to apply all this stuff up here to this motion to dismiss. But the court said other judges in the 11th Circuit and other circuits have applied this stuff about, legal versus factual. And, you can read this, and I'll have a link and a comment here to this, particular case, but just a ton of cases here that talk about, like here's one. Let me highlight this. Proper resolution of a legal defense to payment of debt. So let me give you an example. Let's say that I take out a loan and it's 500% interest. And they report me negatively on my credit report. And I say, well, actually, the interest rate is too high. And, based on the choice of law provision and the contract, we really operate under, North Dakota law. And you can't be 500%. And so therefore, it shouldn't be on my credit report. Well, a lot of judges are going to say, that's really not the role of the credit bureau to decide that. Now, that may be a valid dispute. You may still want to do that dispute, but just don't try and sue the credit bureaus. You may end up suing the furnisher who knows that that's an improper type of loan, but don't sue the credit bureaus. All right, so let's go on. And here's where we get to kind of the way that the judge handles this. Because the judge is saying, look, I see all these cases out there that do distinguish between legal and factual. But the judge says in this case, the Solus versus Regions Bank case, I think it's a factual dispute. Well, what's the factual dispute? To determine whether factually disputed information was inaccurate because TransUnion said she voluntarily surrendered. But The plaintiff says she did not voluntarily surrender. She did not ask the vehicle to be towed. She did not know the vehicle had been towed. And so she disputes this. And the judge says, look, I did something that maybe on the face appears to be a little bit similar, where I went the opposite direction. Let me explain why. So it says this is different from the Batterman case that recently occurred. And in that one, there were liquidated damages for early termination of apartment lease. And so the plaintiff says, look, I could do that. I could terminate and not be charged because there was flooding, there was mold, it was uninhabitable. And then when this popped up on the plaintiff's credit report, the plaintiff disputed it and said, I want a reinvestigation. And here's what the judge said. The court dismissed those claims, finding the plaintiff had not presented the credit bureaus with a factual dispute, but had requested they investigate a contract dispute, turning on the questions of whether the apartment became uninhabitable, whether the lease automatically ended or was terminated prematurely. Now, I'll say this. I don't agree with that. And obviously, the plaintiff did not agree because even the judge points out that this ruling on April 10th is on appeal to the 11th Circuit. I would say this is a factual issue, not a legal issue. And this is where this is starting to get, it's a little bit of in the eye of the beholder. What does your judge think? Does your judge think this is legal or factual? And so here, the plaintiff, going back to the Regions Bank case, says, I want you to investigate this factual inaccuracy. Did I voluntarily surrender? And the judge says, well, let's look at the dictionary. Voluntary is done by design or intention. And so the judge says, TransUnion only had to reinvestigate whether plaintiff by intention surrendered or relinquished possession of the Nissan to Regions Bank. That's the factual dispute. Now, TransUnion says, well, really, what the plaintiff is fussing about is whether this was a wrongful repossession. And, they point out that it could be that you did not voluntarily surrender and Regions Bank did not wrongfully, involuntarily repossess the vehicle. But the problem is that we look at what the plaintiff disputed. The accuracy that she voluntarily surrendered the Nissan. Her dispute was not, there should be no notice whatsoever of repossession. That, I think, with this judge might have been too much. Now, again, I don't agree with that. Okay, I think it would have been perfectly fine for the plaintiff to allege that broadly, but it does teach us this lesson. You may dispute broadly, but then get specific. Be very, very specific. TransUnion, Equifax, Experian, whoever. I want you to investigate whether I voluntarily surrendered it, because I'm telling you, I did not voluntarily surrender. So go ask Regions Bank what evidence they have that I voluntarily surrendered it. Now, I don't know what the dispute letter said. I'm just saying that's what I would do. Is you just put this, and it doesn't have to be in any magical language, just conversational. Hey, go ask Regions. They say I voluntarily surrendered it. How do they know I voluntarily surrendered it? Did I turn it in to them? Did I drop it off at a Regions Bank branch? What did I do? Ask them those questions because they won't tell me, so maybe they'll tell you. And if they won't tell you, that should be proof that they are not doing this the right way. So the court says, look, I'm denying your motion to dismiss the complaint. And then this case will move on. So it'll be interesting to see how this case progresses. But again, I want you to see this because this is starting to become more prominent in cases. And the credit bureaus and even the furnishers are looking for what they perceive to be weak cases. Maybe somebody's suing without a lawyer. Maybe they have a lawyer and their lawyer's not real experienced with this. And look, I don't know on this Solus case, maybe the best Fair Credit Reporting Act lawyer in the world. I'm just saying that bureaus in particular are looking for what they think are sort of weak cases so they can win them and then get a judge to maybe go beyond what he or she has to do to make bad law. So it's very smart what they're doing. I don't like them doing it, but I have to give them credit. It's smart. So we need to be smart on the consumer side, bring the right cases, and push the right cases. So hope that you found that helpful, and always feel free to subscribe to our channel, and I'll catch you guys in the next video. Okay, thanks for watching. Bye-bye.